Honorable Court of Criminal Appeals is now back in session. Please be seated.
All right, for those of you who are here this morning, musical chairs, but I am Judge Matthew Wilson from Jackson. And then to my right, we have Judge Tim Easter from Williamson County. And then to my left, we have Judge Rob Montgomery from Kingsport. We're going to hear the two cases this afternoon. And again, there will be 20 minutes per side. The appellant can reserve any time they request for rebuttal. Make sure you tell us up front. Madam Clerk, before we start, are there any preliminary matters this afternoon?
No, Your Honor.
Thank you. Call the first case.
State of Tennessee versus Roger Trino Spencer Jr.
Good afternoon, Judges Wilson, Easter, and Montgomery. Raven Priya Morris with the Appellate Division of the Public Defenders Conference here on behalf of the appellant, Mr. Roger Trino Spencer Jr. Judge Wilson, may I reserve 4 minutes for rebuttal?
Yes, ma'am.
If time permits, I intend to discuss each issue raised in Mr. Spencer's briefs, addressing any questions the panel may have relating to each. First, the identity evidence presented at trial is insufficient to support Mr. Spencer's convictions beyond a reasonable doubt. The state also engaged in prosecutorial misconduct when it argued facts to the jury not predicated on its proof submitted at trial. And finally, the trial court abused its discretion when it set fines and restitution without first making relevant findings as it relates to Mr. Spencer's financial means. The crux of this appeal is grounded in the most material issue presented at trial, and that's identity. Putting the prosecution's improper arguments relating to its identity evidence aside, the state's proof at trial fell short of proving Mr. Spencer's identity beyond a reasonable doubt. Based on the proof actually submitted, jurors were tasked with answering a very important question. Is Mr. Spencer, the white-shirted individual captured on surveillance footage, robbing a Dollar General with another individual? The state's proof consisted primarily of testimony from 3 witnesses on this issue. One of the store clerks positively identified Mr. Spencer as the man in the white shirt at trial. However, this identification was inherently unreliable because the circumstances in which the store clerk viewed the white-shirted gentleman would not allow a positive identification to be made. As depicted in the surveillance footage, 2 black men approached the checkout counter, both with their faces covered. The white-shirted man also is wearing a headscarf in the form of a bandana. As the store clerk admitted, she only glanced at the 2 men when they first entered the store. Despite this, the store clerk insisted that she was able to make a positive identification of the white-shirted man at trial based on observing the man's eye features, his hair, which was fully covered as depicted in surveillance footage, and rewatching the cameras. So in actuality, this was a cross-racial identification based on observing the white-shirted man's eye feature in a matter of 2 minutes. And the store clerk offered no testimony relating to any unique eye features of the white-shirted gentleman at trial. This unreliable identification alone or in conjunction with other circumstantial proof is just not enough to prove identity. A semi-truck driver also came forward after seeing 2 men emerge from a car on the side of the road that resembled the 2 men involved in the robbery, based on viewing the McNairy County's Facebook posts seeking more information on the robbery. Notably though, this eyewitness was not able to recall the license plate of the car he observed, and he also admitted that there was nothing that stood out about this car that would aid him in picking that car from other cars that he saw on the road that day. This eyewitness simply picked the black car that was captured in the flock camera system that passed through a few minutes before he did. And he also admitted that he couldn't say for sure that the car he identified from the flock camera system photographs, which includes a timestamp of 9:01 a.m., which is at least 2 hours before the robbery, was the same car that he saw the two men emerge from on the side of the highway. Investigator Carter ran the tag numbers of this car, and it came back to be registered to Mrs. Tabrika Spencer, Mr. Spencer's sister. That investigation then led Investigator Carter to Facebook, in which he gathered several photographs of Mr. Spencer. Investigator Carter suggested to the jury that Mr. Spencer was the white-shirted man involved in the robbery simply because he owned a generic pair of white and black shoes and a dark-colored bandana.
So you have all these factors together, but the jury heard all this information, correct?
Correct.
All right. So even with what you're stating, the unreliable identification, I mean, how is that not entirely the jury's prerogative to decide that issue?
So, sure, questions of fact and the weight of admissible evidence are questions of fact for the jury to resolve. But the law affords meaningful appellate review of this issue because the court must determine whether the store clerk viewed the white-shirted man under circumstances that would support a positive identification to be made. And this essentially guards against the risk of wrongful convictions based on unreliable witness identifications. And as discussed previously, the circumstances in which the store clerk viewed the white-shirted gentleman just doesn't support a positive identification, alone or in conjunction with the relatively weak generic identity evidence that was presented at trial. So also just to go back really quickly on the Investigator Carter's testimony, the surveillance footage even illustrates that one of the store clerks wore a headband essentially the same one as the white-shirted man involved in the robbery. So these generic items just are not sufficient to support proof of identity and therefore creates a reasonable doubt as to Mr. Spencer's guilt. Now, despite presenting relatively weak identity evidence, the state repeatedly, in its opening statement and closing argument, told the jury that the issue of identity was essentially resolved because law enforcement officers had received a tip specifically naming Mr. Roger Trino Spencer Jr. as the white-shirted man involved in the robbery. But not one witness testified to this fact, and that is what makes the state's arguments to the jury so egregious. Now, these arguments were not objected to at trial, so we are operating under plain error. But, as State v. Enix illustrates, that does not prevent this court from reviewing this issue. Briefly, I can touch on how each of the plain error requirements are met. The record includes transcripts of the trial, complete transcripts, which necessarily includes the opening statement and closing argument of the state. As outlined in State v. Sexton and State v. Goltz, a clear and unequivocal rule of law was breached because the state argued facts to the jury that was not predicated on its proof submitted at trial. Mr. Spencer's right to a fair trial was therefore adversely affected. Trial counsel's failure to object to these arguments was not tactical, and consideration of this issue is necessary to do substantial justice. Not to belabor the point, but the state essentially unfairly bolstered the most contested issue at trial by arguing facts to the jury that it had not presented, essentially stating that the identity issue was resolved. And this prejudiced Mr. Spencer from his right to a fair trial. The state's argument on appeal that the prosecution's arguments were actually predicated on proof submitted at trial is just not supported by the record. And the record just truly speaks for itself on this issue because not one witness testified to the McNairy County Sheriff's Office receiving a tip specifically identifying Mr. Spencer as the white-shirted individual involved in the robbery. Turning to the sentencing issues, plainly, the trial court's imposition of $15,000 in fines and $971 in restitution is not proper on these facts. First, a trial court's role at sentencing after a jury has assessed fines is not to simply automatically apply the fines as assessed by the jury. Instead, a trial court's imposition of a fine is to be based upon considering several statutory considerations, like prior history, potential for rehabilitation, any mitigating and enhancing factors that may be present, and as relevant here, one's financial means. The record does not demonstrate that the trial court made any findings relating to Mr. Spencer's financial means before imposing the $15,000 fine as assessed by the jury in this case. The record also just isn't clear on whether or not the trial court understood its role separate and apart from the jury in its imposition of fines at sentencing. There are several cases from this court that support a remand under these circumstances, which are cited in Mr. Spencer's principal and reply briefs, namely State v. Shanklin and State v. McCracken. The trial court did make one comment, though, after imposing the $15,000 fines and before ordering $971 in restitution as requested by the state. And it was based on Mr. Spencer's voluntary testimony at the sentencing hearing relating to his background and general employability over the course of his lifetime. The trial court's comment, and I quote, is, "When he is released, he is employable." Inherent in the trial court's comment is its belief that Mr. Spencer will be released before the expiration of his 18-year sentence. And from reading the state's response brief, it seems as though the state tends to agree with this logic. However, the flaw in this logic is the fact that there is no guarantee that Mr. Spencer will be granted parole after serving 85% of his 18-year sentence. And he could very well serve his entire 18-year in confinement. So the trial court's comment that when he is released, he is employable, it just does not satisfy the statutory requirement in effect at the time of these underlying offenses for the trial court to consider Mr. Spencer's financial means and ability to pay within the acceptable time frame.
What did the defendant himself say about his future employability? Wasn't there some statements that he said he could regain his job at Amazon or somewhere like that?
True, Your Honor. Mr. Spencer did make several comments relating to his employability over his lifetime and that he, thought that he could regain employment at some of those prior jobs. But I submit to you that it's just a little disingenuous to think that after serving almost 2 decades in prison, that is the reality that could occur, especially after serving his entire sentence in confinement and possibly not released before the expiration of his sentence.
There was no objection about the restitution piece, correct? Did his attorney at sentencing object to the amount of restitution that was set and the ability to pay it?
No, Your Honor. There was no objection at sentencing relating to restitution, but there is case law that is cited in Mr. Spencer's principal and reply briefs that support still granting review of this issue because the trial court didn't make any findings relating to his financial means on the record.
I'm not sure I follow your logic on this. Even if he has to serve his whole sentence, why he wouldn't be employable? Are you just saying in 18 years from now he would not be employable?
No, Your Honor. Because of State v. Cavan and Givedon, restitution orders must be satisfied within the duration of an individual sentence. So after Mr. Spencer has served his entire 18-year sentence, he would no longer be under the trial court's jurisdiction, and the trial court would not have jurisdiction to mandate him to make any payments. So if the trial court's belief is that when he is released after serving at least 85% of his sentence, he will be employable with about 5 months if he's released exactly at that mark. It's just inherent that he would be employable, find a job, and be able to make satisfactory payments within that short time frame. If he is not released before his 18-year sentence expires, there will be no opportunity for Mr. Spencer to make any payments towards restitution.
But I thought that if it was unpaid after the service of the sentence, that it could be converted to a civil judgment? Am I mistaken on
No, Judge
that?
Montgomery.
Restitution? I'm trying to remember.
Yes, you're not mistaken on that point. But as Cavan and Givadon does illustrate, that factor alone cannot be enough to support a trial court's order of restitution.
Okay. All right.
So if this court has no further questions, I reserve the remainder of my time for rebuttal. This court should either vacate Mr. Spencer's convictions or remand for a new trial. Alternatively, this court should remand for a new sentencing hearing with instructions for the trial court to hear proof on Mr. Spencer's financial means and ability to pay before setting fines and restitution amounts. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Brooke Huppenthal on behalf of the state. This court should affirm the defendant's convictions and the trial court's judgments. First, the evidence was sufficient. The evidence of identity was sufficient to support his convictions. First, the defendant asked this court to reweigh the evidence regarding witness credibility and the circumstantial evidence, all of which were jury questions in this case. Ms. Morrison's sufficiently had identified the defendant. She was the store clerk in this case. She saw him when he entered the store. She saw him when he came and approached her at the register. He had leaned in closely to her several times. She was one of the individuals who was, she was standing up the entire time and saw him throughout the entire part of the robbery where the other cashier was pulling cash out of the safe, and which was kind of on the ground. And she had Ms. Morrison had identified the defendant based on his eyes and his hair. And that was enough proof for the jury to for the jury to presume that she had accurately identified the defendant. And even if this court does not find that the identification was sufficient, the circumstantial evidence does support his conviction as well. We have Mr. Redmond, who was the truck driver. He had seen the defendant's sister's vehicle on the road before the offense. That vehicle was on the highway and it was parked about 100 yards from the dollar store. He saw a man in a white shirt wearing a bandana get out of the vehicle. Later on that evening, he saw a press release photo and recognized the image of the perpetrator in the white shirt as that person who had walked out of the vehicle on the highway. And he recalled that the vehicle was a black four-door sedan, and they had gone through the flock system images, filtered those vehicles based on the time in which he had passed on the highway, and he was able to identify the vehicle. He testified with 100% certainty this was the vehicle. And that vehicle had been captured by the flock system cameras before and after the offense. But during the entire time that the robbery was taking place, no flock system camera had captured this vehicle. Additionally, the man in the white shirt had opened up the Dollar General store by pressing his hands on the door. And officers had lifted the fingerprints from that area, and it matched the defendant's. And based on this evidence, the jury could have reasonably inferred that that the defendant was the man in the white shirt in this case. Second, the prosecutor's comments. The defendant is not entitled to plain error relief here because he had used the the identity of the tip against, essentially to his advantage. The comment that the defendant cites in the reply brief is actually a statement that was made by defense counsel in closing argument. And the defendant had used that to bolster questions about who was the person who had actually called in and gave this tip. And it's clearly based on strategy. Additionally, there was proof supporting the prosecutor's comments. We have the jail call where the defendant tells somebody that somebody gave the officers my name. And we have another officer testifying that they had received a name on their tip line. And so in light of all of that evidence, the proof fairly supports the prosecutor's comments. And additionally, the defendant had relied on the tip itself strategically during closing arguments. Next, the defendant had waived the absence of the risk and needs assessment. He affirmatively waived any objection to the pre-sentencing report. He didn't waive it specifically to the risk and needs assessment, but for that reason he did, because there was an original pre-sentencing report and then there was an amended report. And it was obvious he had reviewed both, and he stated he had no objection to either. And in State versus Ross earlier this year, this court held that if the risk and needs assessment is merely just absent and the defendant fails to object, that is insufficient for waiver. But this case is different because the defendant affirmatively says, I have no objection to this report. Further, the trial court had relied on information within the specific data report, information that would be similarly found in a risk and needs assessment, including biographical data, potential for rehabilitation, sentencing alternatives, criminal history, so on and so forth. And eventually the court had reached the conclusion that the defendant was at high risk to commit another crime on probation. And ultimately, the defendant benefited from this amended pre-sentencing report. As I had discussed in my brief, he had a reduced range. The difference between the original and the amended pre-sentencing report was his range. It was originally range 3, but the amended report stated that it was range 2. However, based on the crimes that he had committed, they wouldn't have merged under the 24-hour rule. So in essence, he really benefited from that range reduction. And
How did the range get reduced? I don't understand that.
You know, it's not entirely clear from the record. The prosecutor stated in the sentencing hearing that it was due to the 24-hour merger rule that they had reduced the range. Right. But after analyzing it on my own, it wouldn't have been reduced. However,
So the judge was in error?
oh, based on
sentencing?
well, so the parties had agreed to the range.
Oh,
The parties agreed,
Oh,
yes.
okay.
And so ultimately, he did benefit from a sentence reduction due to that decrease in range. And
But that was as a result of an agreement?
yes.
Okay.
And additionally, the defendant doesn't cite any information that would have been included in the risk and needs assessment that would have ultimately benefited his sentence overall. Next,
Well, it wasn't probatable anyway, was it?
no, it wasn't. It was not. And unless there are further questions on that issue, the trial court also acted within its discretion in imposing the fines. He had waived his claims regarding the fines because he first agreed with the trial court about the jury's assessment of the fines imposed or assessed. And he didn't object to the fines. He didn't argue against the fines and their imposition, and he didn't present the issue in his motion for a new trial hearing. And this court has held as late as this year in State versus Mahaffey that a defendant must raise the issue before the trial court and attempt to reduce or waive the fines or lessen them, or else they waive the issue. And there is a collection of case law supporting that imposition. And ultimately, fines are considered as a part of a defendant's entire sentence. And so we look at the considerations within the Sentencing Act. And the trial court made all of these considerations, and the record does support the fine. We have him, he was evaluated as a range 2 multiple offender. His criminal history contained several crimes of violence. The jury convicted him of now additional crimes of violence, and the trial court had explicitly expressed concern about the nature of these new convictions. And again, while it wasn't a probatable offense, the trial court did consider his criminal history and the fact that he had previously received alternative sentencing and concluded that he would be at risk of committing another crime if he was placed on probation. And fines additionally can be punitive ultimately, and again, it's considered as a part of an entire sentence. And here the record supports that the trial court had made those ultimate findings, of course, excluding the risk and needs assessment. Finally, in terms of restitution, the trial court also properly imposed $971 of restitution. That is the amount that the Dollar General store clerks had handed him. And the defendant said he could pay $200 per month towards court costs and fines. Now, I understand the defense argument that because he's serving a sentence of confinement, that they wouldn't be able to impose restitution. But and this case is different. Of course, if he was serving at 100%, that would be different than if he was serving at 85%. And because the trial court, because there was time, there would be potentially time left at the end of his sentence for him to serve, he would be able to pay that restitution based on the information he provided in the specific data report. And trial courts don't have to be accurate about a defendant's ability to pay. It has to be in a reasonable amount that a defendant can pay within the time, within the jurisdiction of the trial court. And based on that information, it would be, he was serving an 18-year sentence at approximately 85%. That would leave him around 2.5 years to pay his restitution. If he could pay $200 a month towards court costs and fines, that would take him about 5 months to pay. And that would leave him with enough time to pay his restitution. And even if a trial court is wrong, that wouldn't invalidate the restitution order. And Judge Montgomery, as you did mention, it can convert to a civil judgment. Ultimately, restitution, it is not limited to victim compensation, and it aims to punish and rehabilitate offenders. And here, the trial court had implemented this restitution, considering the factors of the offense and the fact that he had always maintained a job. He was previously a full-time student while he had a job, and he was confident Amazon would rehire him. And in light of that, the court found that the restitution was reasonable. And for that reason, it did act within its discretion in imposing restitution. And unless there are any further questions from this court, the state asks that it affirm. Thank you.
So several points, Your Honors. First, yes, there were fingerprints of Mr. Spencer's found at the front door of the Dollar General, but in light of trial counsel's admissions and opening statement that Mr. Spencer was in the area and perhaps visited the Dollar General at some point during his visit from Nashville to Jackson, his fingerprints on the door does nothing more than establish his presence at the store at some unknown time. Second, we are not asking this court to reweigh the identity evidence that was introduced at trial. We are simply asking this court to determine whether the circumstances in which the store clerk viewed the white-shirted gentleman would permit a positive identification to be made. Just to note for the court's knowledge, this store clerk also inaccurately estimated the number of individuals who entered the store that day. There had been at least 10 people that had entered the store at the time of the robbery. And the white shirted man's hair was completely covered. And that's depicted in surveillance footage, which would prevent the store clerk from being able to observe the white shirted gentleman's hair. And that is one of the bases that the store clerk gave for being able to make a positive identification at trial. Trial counsel's discussion of the state's arguments in its opening and closing statement was not tactical, because essentially this was just an oversight. This was the most material issue discussed at trial, as I've stated, and trial counsel simply responded to the state's arguments in its closing argument. And that's kind of what makes the state's arguments so egregious, because they not only argued them only at closing, but also during its opening statement. So I would submit to you that trial counsel's discussion was not tactical and just an effort to respond to the arguments that were made at trial that goes to the most contested issue at trial. I also want to touch a little bit on the sentencing issues as it relates to the pre-sentence report and whether or not that was waived. So first, we do not contest that there was not an objection made to the lack of a strong R assessment in the pre-sentence report. That was actually a specific data report, but it was just labeled and referred to as a pre-sentence report during trial. But when dealing with sentencing issues, and specifically as we are here, statutorily mandated considerations, this court has found that acquiescence does not result in waiver, namely this court's previous opinions in Marshall and Rice. And there is a difference between waiver and estoppel. So most importantly, after this court's recent opinion in Ross, which was just several months ago, the only question is whether Mr. Spencer should be estopped from raising an issue with the specific data report after failing to object at trial. And given the circumstances of this case, we are willing to concede estoppel here. So the only way for this court to not remand this case back on the basis of an inadequate pre-sentence report would be to find that Mr. Spencer is estopped from raising the issue. And even if this court does find that Mr. Spencer is estopped from challenging the pre-sentence report, the trial court sentence as it relates to fines and restitution should still be reversed. And as cited, I see that I'm out of time, but as cited in Mr. Spencer's principal and reply briefs, State v. Shanklin, which was decided in 2021, there was no discussion of trial counsel's failure to object at sentencing in either that case or McCracken in reversing and remanding a trial court's imposition of fines. And one last note, a release eligibility date does not guarantee release. So the trial court's comment that when he is released is employable just simply does not demonstrate trial court's understanding of its role at sentencing as it relates to fines and restitution.
I'll ask you a question about fines. So the jury constitutionally has to set fines, correct?
Correct.
Okay. And so when the jury has set the fine and the judge is in the process of sentencing, does the judge have to make, without the request of the defendant, a determination as to whether the fines are appropriate and/or the defendant's ability to be able to pay?
Yes. The trial court does have to make its own determination as to whether or not a fine amount is appropriate and not just simply impose an amount of fines as assessed by the jury.
Well, okay, so if the judge finds that the amount's appropriate based upon the nature of the crime and the nature and circumstances of the crime, they find it appropriate, is that all the judge has to do?
The judge also has to consider certain statutory considerations. And in this case, what's most relevant for our discussion is an individual's financial means.
So if a person's indigent, they're not supposed to get a fine?
Not necessarily, this is a fact-determinant issue.
But what fact, if a person's indigent for purposes of counsel, wouldn't they be indigent for purposes of a fine?
I think it depends on the fine amount. I don't think there's a per se rule that could be made for every fine, if there was, per se, like a $50 fine imposed.
Well, 50 can be imposed without a jury, so, but if it's over 50, it has to be done by jury. Okay, I was just curious if you had a thought on that.
Yeah. So if there are no further questions, this court shall either vacate Mr. Spencer's convictions because identity evidence was not sufficient, or reverse and remand for a new trial because the state engaged in prosecutorial misconduct in its opening statement and closing argument, and alternatively, remand for a new sentencing hearing on the limited review of the trial court's order as it relates to fines and restitution. Thank you.
Thank you, counsel. Thank you, General. Well briefed, well argued. We'll consider the case. Will you call the next case, please?
State of Tennessee versus Jasmine Moore.